Prosecutors and defense attorneys are used to battling it out in the courtroom, but now they are also battling in the State House.
Few people have heard about it, but dramatic changes to the public records law are being proposed in the budget bill, which recently passed the House. Those changes could not only affect how we do our work, but also wrongful conviction groups. Lead investigator Brian Duggar has the story.
In the last 6 months, charges were dismissed against 5 men previously convicted of a 1992 murder in Toledo's Wilson Park. Now, Toledo police didn't provide the defense or even the prosecutors with evidence that could have cleared Eric Misch, Lorenzo and Mel Vasquez, Louis Castilla, and Joseph Ricard.
We did numerous public records requests, probably about close to 10, if not more, over the course of a decade. And the records that we finally obtained that led to not only Eric's exoneration, but the exoneration of his 4 co-defendants were records that were in the police file for more than 30 years.
On April 9th, the state took the first step in making life much more difficult for Sanchez and wrongful conviction groups. The Ohio House passed a budget bill that made significant changes to public records law, backed by the Ohio Prosecuting Attorneys Association.
We did support the changes to define specific investigatory work product and make it clear that our attorney work product is excluded from the public records law.
In our 2019 Guilty Without Proof investigation, we obtained the prosecutor's case file, which contained notes and strategy. Our investigation led to the release of Wayne Brady and Carl Willis.
Attorney work product privilege is something that every attorney, including prosecutors, should enjoy. And the public policy behind that is that we want attorneys and prosecutors to feel free to reduce their thoughts to writing and to do that without fear of unnecessary interference.
We need to make sure.
Lucas County Prosecutor Julia Bates provided a statement which reads, in part, "We understand the proposed changes to the public records law and the potential impact on transparency. However, it's important to balance that transparency with the need to protect the integrity of ongoing legal proceedings." But on page 463 of the spending bill, specific investigatory work product is defined as information gathered by police for a likely criminal proceeding, which could be interpreted as during any part of their investigation. And on page 473, attorney work product is defined as a record created for an attorney in anticipation of litigation. Now that could include any police record put together for a prosecutor. Law enforcement and attorney work product would be exempted under the bill, possibly hidden from any examination, ever.
I do a lot of international work, and you see stuff like this in like third world countries where they don't have transparency laws, they don't have sunshine laws. Most states here do, and like if this is interpreted in the way that I think they're going to try to interpret it after it passes, it's kind of like putting Ohio up there with like some of these third world countries and not having transparency in public records.
Mark Godsey co-founded the Ohio Innocence Project, which has freed 43 wrongfully convicted people.
If the law was how they want it to be, of that 43, how many would you guess that you would have been able to still get out?
I'd have to do the math on it, but close to zero.
Prosecutors want to sideline the 2022 Ohio Supreme Court ruling in Myers versus Myers by strictly defining and shielding investigatory work product.
Called Myers versus Myers, and it said that if an officer on the scene, while taking an initial incident report, also starts to compile what's called their supplement narrative, which contains victim information, witness information, a victim statement, witness statements, the officer on the scene's initial impressions about what the case might involve. This Myers case said that stuff is available by public records request right away.
11 investigates used supplemental reports in the Brady Willis investigation, the Johnny Clark Lisa Straub report, and the investigation in the 2009 murder of Grace Kennedy and Bryan. Supplemental reports actually showed police believed the murder weapon was a lamp, information not previously reported. In our Cedar Point investigation, which uncovered dozens of sexual assault claims, was driven by police supplemental reports. Those would not be available to us under the proposed law. Sanchez relied extensively on early police notes in the Mish case.
And the most critical of those records were handwritten police notes from an interview with the victim's uncle that completely upended the state's theory of the case and pointed to Eric and his co-defendant's innocence. And this kind of record is something that potentially could be shielded under these proposed amendments.
Now, a similar attempt was made for changes to the records law 2 years ago. These changes also were added to a budget bill.
We had to man the phones like nonstop for like 48 hours, calling every like senator or representative and saying like, look, this is bad stuff. And, you know, even if you're not even sure, this should be a standalone bill, not stuck into a budget that, you know, people find out about by surprise at the last minute.
Now, Tobin and Bates are concerned about early information being released and potentially derailing a case.
That's very concerning for victims and witnesses, because if their information is available to the public right away, that really increases the risk that they're going to be subjected to witness intimidation, and it really increases the risk that the investigation is not going to get off the ground at all.
So this is why page 454 included an addition that trial preparation records would not be available until after a direct appeal. However, there is no end date for the police records or attorney work product, meaning technically those records may never be released.
The specific investigatory work product provision needs to have a sunset provision that's very similar to Section G for trial preparation material. So after trial preparation material sunset, you need to basically repeat the same thing, but for specific investigatory work product. So that's number one. Number two, the definition of attorney work product later in the statute, in the bill, needs to either be removed or a sunset added to that one. And it also needs to make clear that attorney work product is not talking about the police file.
Tobin believes Godsey and others are overreacting to the intent of the law.
I think they're being a little hyperbolic about what it does. I want to be very clear that anything that's factual, that's in the case file, witness interviews, witness information, lab reports, physical evidence, all of that stuff is still going to be available to the public. It's going to be a little bit longer until they can get it, because we're going to wait until after the direct appeal.
But again, as written, there is no end date for police records or attorney work product, leaving the bill up to interpretation by each department.
If you want police and prosecutors to have the proper training, to have the proper supervision, to have everything work the way it's supposed to look and the way it's supposed to work, you can't have complete secrecy, because through time, corruption will grow and more people will start doing things the wrong way. What keeps powerful people in check is transparency.
The Senate's expected to vote on this bill in June. It could then become law. Now, Godsey wants the process to slow down, addressing the concerns of prosecutors, but also allowing for future examination of cases.
If you allow this to go forward and allow these laws to take place and they are interpreted the way I fear they're going to be interpreted, we've lost all oversight in Ohio, and we can be put in a category with like third world countries in Africa that have no transparency in their criminal justice system.
Now, what we don't know is whether these changes are going to make it through the Senate or whether they're going to get stripped out. But in the weeks ahead, we're going to be asking state senators what they're planning to do. Now, more on this story can be found at WTUL.com. Reporting in the newsroom, this is Brian Duggar for 11 Investigates.